this particular petition, why petition ABBA, and my men some fans also say, your fourth republic way, Chief Justice BN who I send the petition, Aqua President Amaya Unedida. And you can understand the panic on the side of the Chief Justice. Or making sure that this whole thing and Sabakan and Tem na while responding to whichever way. Chief Justice BN who I bar, the petition a unity. And this particular one, a go through is going to be the first time I under this fourth republic. So let's put that particular thing on record. But the question is, Adeba Yenya and Shannon, so say, before Nana Kufuado, A.B. Frekundiano, so a similar petition was submitted to him by Professor Kokuaza. Or enumerating a number of reasons why or no free say, Mamia Otiwa Chief Justice, Wafo Membra, and for that reasons, who here say you be in a free hall. Because we had the Constitution Article 146 down was now a stating reasons I ever fast what you bet me a Chief Justice said when there is misbehavior, demonstration of incompetence, and the infirmity of both physical and body and mind. These are the three cardinal reasons constitutional framers in the torture wise say a hapena. You bet me Gina so na ye Chief Justice be free. My culture said this particular process, ye trigger ye successful that. This is the first time you say ye be who say a bet me go through and I say ye go through. But the question is say a day na beba ama or man for sorry say baby ye do emraso say ye prune ye justice delivery system several petitions. My culture say answer na Kufuado because there was a petition or no the autopsy. I'm not even sure whether that particular petition was forwarded to Council of State for any consideration. Or Kachira and said that particular way was frivolous. So that particular offense and petition was jettisoned or more topshiny baby. But answer President Mahama taking over may sure say 90 days and 100 days about. But 4 petitions so far. 3 petitions and I just submitted to the president that were forwarded. So the basic question as he said was why this interest man for us submitted a lot of petitions to the president asking or calling for the removal of the Chief Justice. This is a fundamental question. Yenya answer to it. The happy subsequent Nema A will be irrelevant. Because that is why people will find it quite convenient to say because abanya banti, abanya sentina, abanya no fa kwan bi so ayi na firi ho. But we should know say abra abanya nsesan yakora no. Now there will attempt by some Ghanaians, some individuals who felt to say and nema koso ewe judicial space enye healthy and gender trust and build the confidence in this institution, and for that particular reason Nipa Bakwa all supervising over these things the Chief Justice, and for that reason the Chief Justice must go. So this particular thing was triggered even before President Mahama took over. So and yes, I buying Bia Santina this particular way. That is the point I want to make. And again, so we had Nema Yaka Huasem Ewo Krum ha. So person will give you credence and I will give you evidence to justify why Ghana for yes Nema way. You can go online and in recent times, the number of Nema Akoso Krumha your judiciary involved are deepen public trust and confidence in this institution. Major decisions are free Supreme Court about and how some of the judges at the bench carry over home. Some of the rulings sometimes it's funny. You see about them 4-5 crowd who go good demo. Now we your friend is saying the same thing chiro mo no ba bontia. Hardly now benya so mu nyina adwene ekobem krom. We got to a timer. Every single judicial ruling coming from the apex court of the land, came out unanimous for a period of about 4 to 6 years. I will chroma say, Emma, again, some notoriety. I will chroma social media. The judiciary in Ghana became a subject of public ridicule on various social media conversation. You heard of unanimous FC, and so all these public mortification the judicial system was subjected to Ep1 to wane and a kill public trust in this institution anywhere in the world. Justice delivery system, no, the basic element so trust and confidence among for a womb. So at any point in time, if you gauge that level of trust and confidence, not anywhere, trust me, that institution is no longer a justice delivery system. A terror arm of power. Some individuals being used to bulldoze their way. And within the last 8 years, that is the perfect description some of us can give to the judiciary. For instance, one of the landmark ruling by I pertain to birth certificate ne Ghana card ne honsensema. The ruling by trigger whole lot of conversation. I'm for beginning to ask questions. What can I say? Now subjected some of the rulings to critical scrutiny, intellectual scrutiny, logic, reasoning. You don't find this element. You could see clearly that even though this is a ruling coming from the Supreme Court, but for what I know about law, there are basic elements, reasoning, common sense, and logic. Every single judicial ruling these three powerful fundamental elements should never be missing. It can never any that thing ruling. But for a number of your friends saying years or said you ruling Bible, ordinary man on the street can just they're ruling that became the order of the day. And no can be that was the beginning of the fall of the your friends the integrity and Ghana for war in the judiciary. So a course to a point, and sometimes paneling at the High Court, your friends at the Supreme Court, we realized that there were even some complaints. A certain category of people were the very people, all the cases, your panel, you could see, say, there are a number of judges on the Supreme Court panel, but consistently, it was the same group of people. The but consistent. And they were giving the same ruling time and time. And you got to a time people got tired of this whole thing. And because Menyamba, dear President Akufo-Addo, packing the court in Menyanka. But these are some of the things that now air course within the space. Emma Ghana for Abamu in some of these instances. Allegations of corruption, bribery, and so forth popping up. And some of the judges were even at the time, Makai Justice Animia on a lawyer big case, then as a phone. I don't know how well that particular issue was investigated. I clear doubt of the public on some of these things. Yet he understood the judge, the lawyer has been suspended, whole lot of stuff. But as to whether say actual investigation, detailing Nema so any proper fundings are because as some nobana is see in the dark, you can handle it in the dark. But once it happens within the public space, now man for making informed decision and some impressions about the issue, the reverse must also involve the public. Yes, baby, I teach you sign, but they cannot be a public exposure to such a sensitive matter, and its resolution, is done in the dark. You dip public confidence, and it's one of the major things that aid your judiciary in recent times. And then apart from panel, we can also look at the urgency in dealing with some of the issues across the Supreme Court. Akwesa assembly be choose date na it depended on somebody's discretion. For instance, Obeka said there has been a number of times. One has to do with the yield levy case. We know that this particular thing was a landmark. It was a very crucial issue. It triggered a whole lot of conversation in this country. At the time, not approval no because some individuals went to court to challenge that particular thing. But you know what happened? Date na yesterday for that adjudication, ebeduru hono na your friends say adnekwa ya passing na ya ho hwe. And this thing was deliberate because the meaning say in a civilized democratic country like ours, always you must seek to distill that the kind of misconception and make sure say emra be adwuma and amra no adwuma ne atentene ne pepepe because we the party mu. So looking at the political implications of that issue and how critical it was, whatever it is, it should be urgent for the Chief Justice to ensure that obedi saa asɛm no even before date a yɛde ayɛ 11 abatoɔ no bɛduru hɔ. But daabi yɛtena ase bu yɛne gu so ma ɔmo yɛ deɛ ɔmo bɛyɛ awie. So ano de wobɛkɔ akɔdi asɛm no na yɛ useless. And while we follow this discussion, you agree with me, say that particular thing became the order of the day. Asɛm na yɛ crucial, any politically connected issue biya, very huge biya bɛkɔ Supreme Court biya no. There is a window of commission yɛ create for whichever agency government to do the thing even before the Supreme Court will set the first a date for that hearing. Classic example, Electoral Commission. When they attempted say omo ebeye your friend is saying idea we me sure say wokai. When Electoral Commission set it say registration omo ye no will not happen at the electoral areas. Nambum ya the air district level. Me binum had a lot of issues with some of these things because Ghana said the city no. So wokasa wo ye voters register at the district level, especially if you go to places like Northern Regional. Distances near very wide. How do you expect people to travel all the way some 5 kilometers to the district level? No munko register. Obikona when Timmy registered that day. It was going to create a whole lot of challenges. So the NDC and 6 other political parties challenges this decision. And then I would say Chief Justice at 2.0 or the date I just said Oba and Sana. Omwenya date this asem no ampa oba ya nsa na yenya date oba ya no or the date no ko share baby or the date no ko share no na electoral commission registration na wie. You see some of these things yes niema we ya ubu amanfo abam the trust and the confidence people are supposed to have in this institution to sustain it, because the longevity of the judiciary whole establishment, contingent on the trust and confidence amanfo womb. Because we see when amanfo judiciary ni si ho na amanfo ni gidi wo ma useless, because you are there for the people. So always, you must avail yourself to the prevailing circumstances. The prevailing political circumstances are also at the time, You must always, that is why Emrano must always be in tune with current happenings. What I say, the people cannot be living in the 21st century and their laws will be operating like in an era of a 12th century. Then as a form, it can't work. So always and always, some of these crucial issues are public, vested interest in. That is why we expect the judiciary to move in quickly to remedy some of these things. One major issue, has to do with ruling na Supreme Court the buyer between the Speaker of Parliament on your friend saying the President LGBT issue, quite clearly. Parliament in the process of all neduma, no other institution and a bit me curtailing the powers and I'll stop from doing a job. Parliament consider bill no ko nyamwie ye na bayamra, because answer na bayamra the processes are quite clear. Ese president ho, my president didn't signature a penny to na eba chese that particular process was not completed. Yet I didn't come out president also on sign because obi the court. He knew very well, sir, the oil or sign control marabia because Parliament was still in the process of oil neduma. As I'm running by, we know be what issue with it that you can take it up from there. But we saw the ruling that came out. But the funny aspect of it, cry and yet ruling now on what the buyer now subsequent process now as a bar one, that particular thing, you to share now to the stand, sir. Bill no, because bill no that Parliament expire. And the last time what is President Mahama said we need to submit a new bill because as a bill no di our Parliament expire. Now we are moving because of this same judiciary attach any sense of urgency to one crucial and most important issue. Na Ghana for nyina issue. One that Ghana not say only interest or this LGBT issue. If you go to the moral space, the moral sphere, a malam for a soft for oba your friend is saying every facet of our society. Everybody was interested in that particular thing. So you use the law, said the agent to settle that particular matter with a certain sense of urgency. Now you are resolving the situation. Me, baby, I want to call, baby, I want to talk, and you assem because I wanna would assem. But the thing is, avail yourself, resolve the situation, and let's move on. But so Ababa said, Abrebia. Ye here judiciary nso obeye adwuma bi ama aban ayede obeye no, we could get the judiciary to do that particular thing to ensure say government will prevail. And this thing became the order of the day for the entire 8 years as President Akufo-Addo betena akonnwa so. And it is the aggregation of all these happenings and then ama general public, any trust, any confidence our judiciary men. I saw a poll sometime before the elections, Joy News for a year, gauging the level of trust Ghana for war in one of the most revered, sensitive institutions, the judiciary. Me say, so who polls now, we yambe show, wabambe boo. And so we'll go a step deeper to look at the comments and Ghana for a try. We should be worried. And some of these things, threaten the very foundations of our democracy. As judiciary yentungum ebedu ba bi obi abeka ba be alone to himself ko onim say the institutions that are supposed to deliver justice are no longer institutions of justice. Na mom abeya a rogue, abeya some kind of a rogue arm of power ye use to terror and just do a whole lot of funny stuff. And then bedura and then ye jina baby ye jina. And Sanyama way didn't also happen in a solution in isolation. A couple with some political decisions be assigned also with the president. We saw some hostile intrusion into the Supreme Court bench by some individuals with some unholy alliance to the power that be at the time. The way and manner people were being promoted to High Court, to your friends Appeals Court, to the Supreme Court itself, it got to a point. Even numbers are now 14. Your friend is saying there is no ceiling. Let me put that right. You see, conventionally, I'm not sure say we've ever gone past 14. But you got to a time there was a hostile intrusion. There was a mad rush. Appointed. If you go to the lower benches in Nasafon, there are a number of people I don't call there. Just an air time. And you speak to insiders within the judiciary. There were a lot of people who were worried about the way and manner now you appointed people, not just the appointment. Now, the very individuals with known partisan ties, with known affiliation to some people, and Sanyama when Nema Akikambo Miyababetra. For instance, Abra, your friend is saying, Speaker of Parliament, and way sem and judiciary that banter back and forth. I don't want to even go into that particular issue. Banter back and forth. Panel na set it up say omontena sa asem no so no. In you see that particular issue na one of the most contentious political issue in recent time. Na a border on judicial and the legislative supremacy. And that tone that particular development NDC MPP issue at the time. Chief Justice way panel judges she thought it right to bring in one individual. I will be name said this person MPP ni or lawyer or contest here Ho East as a parliamentary candidate on the ticket of the MPP. Name say ho very difficult. And away MPP near obetimi winning that seat. So the gentleman lost and of course so practicing the marane as for. Under certain bizarre circumstances, you and Akufo-Addo pager that person, pushing it through the ranks. Pager that person to the Supreme Court. Yes, as for qualification, there nobody is disputing the fact whether say qualifier and I say unqualified. Maka kyerɛ sɛ amamuo no yɛ de adwene ne nyansa na ɛyɛ, and you are dealing with human beings. Our one kasatimi form our own perspective. They have their own impression. And in politics, my culture say perception is very key, very important. You must be a fool to sit somewhere and say, oh, it means that you don't understand governance, you don't understand politics. Because perception in politics is very, very, very relevant, very significant. So that person with known partisan ties, they appointed the Supreme Court bench. It created a whole lot of. I remember that day in Parliament, there was a strong opposition from the other side, but they had the numbers to make sure that man goes through, and he actually went through. Not such a landmark case, now we pay more determine. You go in, bring in the same person. You see, sometimes. And then I give some of us worry to understand, sir. And I did find a common sense, new reasoning. I very people who rise to higher position. I do mutim there. Because under no circumstance, and there is no reasonable, sensible justification for that particular decision I will make here. And this Obakaya deliberately, the lawyer for the Speaker of Parliament, title sorry, on that day, raised an objection, and the objection they say. Papa we ya oye tintin we ya osi ho abitare nani ya oye judge. Ono no obia nim, he said he is affiliated to a political party. Issue here discuss he has political undertones. So how then? And our kwatam no man better bench we so. The gentleman raised an objection. Say ebeya ye nyidum free panel no so. Because me free say senka adwen koma na ya dwene ho na nka ye wo risk. The Chief Justice at the time or set it at the panel, I will respect for the people of this country. Trust me, that gentleman will come nowhere close to that particular bench when you know the issue. And he always did that objection. Yes, as usual, the Supreme Court retired to their chamber. They came back with a ruling. And funny enough, the person who read that ruling is the current Chief Justice. And the reason is quite simple. Justice Jau qualify now over the years what demonstrated clearly say your friend is saying onim dia oye enti being say wa contested for your friends a parliament dakra na eno and kyerehwe na once our qualifications so betimi aye adwuma ne de sa objection na your friend saying lawyer for we are raising omobotugu because nyina so obi ani so issue na at hand a constitutional matter. Let me say this woman is a joke. That issue cannot just be a constitutional matter. We are talking about issue a border on parliamentary proceedings Speaker of Parliament I take a decision to suspend key members of political party. You know the numbers in there very tight. So say Speaker decision to go through one political party will be disadvantaged. And as some no enya nkoko na they call court political actors and they call court. So the issue had political bearings and political undertones. So it was highly unreasonable for anybody to say a constitutional matter. It has no political undertone. No. But I say the law is at the bosom of one now challenge, and that particular decision stood. The Chief Justice allowed the gentleman to sit on that particular panel that day, and they ruled against your friend saying Speaker of Parliament in any way. And no more before, and a main issue, they did not even file a defense. And do back binipa be bradwe ankoso. Main issue na your Chief Justice tell say Speaker of Parliament lawyers file defense biya. So the preliminary your friend says suit na course in some lawyer no troye in his defense and omoko fire and omodi by the main issue and omodi be ruling. What a shameful development. the speaker's lawyer amfile defense in the main issue, no. But omobema ruling, no, they have to go back for the early issue now. Sasem we see, no, no, far the defense that was entered by speaker lawyer, no, etado sorry. I don't know, I don't know, main issue, no, I don't know the more ruling. Anti speaker at the time, no, crab mabu. Ofrizo, where there, just a weird thing, and Ghana for realize the whole judiciary, no, ya weaponize, no. A partisan tool. Some individuals can maneuver, use it. Quite a bizarre circumstances. I find your market proceedings no cost of parliament, or more yet. No speaker could arrival at a decision, but he preempted the speaker's decision and all they call court. The following morning, the Chief Justice asset panel ready. When a yenya contentious issues are not yet thing Ghana forward interest in womb, not yet to and washada. And so the question is what actually was motivating those decisions? I find your mark in the buyer the following Friday morning, they are setting up team, yeah. Now mum dear against the president say as a o sign a bill, Nana said when this o sign a bill, no dear, a da half of web was maybe do. I fear by Ghana for dinner terminal. Now, what they buy so next week they were going to sit on the matter. But at that point, trust be a new. And I am saying all these things just to give a justification to why people will be sending petition. So those of you who are saying that it's politically motivated, unless you know individuals on what the petition no call now one who baby party or war and son one make it. But for me, and all these things are can't way. Enough reason for any Ghanaian anywhere. I will feel it's a near my every time issue with their court. So these issues any political undertone be started even before President Akufo-Addo taking over. And again, the next leg has to do with the petition. I say Tafo MP at the court and as for whether there is sense in it or not. And I'm say we've gotten to a point that the party now will lose power in 2024. We are so badly. Your friend saying you said yes who you know. It is about time as of what yes sober reflection and find a where strategize na why party na be relevant. But some of these clutching and straws, found baby and do political party in them. And some will be a basic room of the press conference. For instance, I do what issue way. Obiako Riesica Pipili say on one a home sem quiet can you name me yet? Addison and then the issue. A young way in a whole press conference. Just a whole, just a near man now more than doesn't show, Sabi. They are trying to put things together just to come back to ensure, say, in the next election, maybe the party can have any chance or not. Because on this particular issue, it is quite clear in the constitution processes as a NIPA go through and sign a Chief Justice through. It's also talk about any of the justices on the Supreme Court bench. And now say chairman of the regional tribunals. So I don't know whether those things still exist or not. In the case of any justice on the Supreme Court bench, petition will go to the Chief Justice. On the bear that determination and as for in consultation with the Judicial Council and as for. But in the case of the Chief Justice, it goes to the President. And the President receive petition. Say or receive petition. And this instead of making quite clear Article 146 downwards. Echo. The processes are quite there. Your friend saying well written, and I think that explicitly, they convey understanding. You don't need any implicit interpretation to say answer what you say. Explicitly, on the face of it, I think that they are quite clear. Processes as will go through. So if the president receive a petition and then the other say all forward it to, your friend is saying Council of State for consideration. Either somebody may establish that prima facie or not. Whether say in the face of the petition relevant, say it may afford it to the next stage or not. So that is the stage you do. You see this lawsuit now for Chief Justice trial letter. The Aquacoma President, Sumasi, say, Mr. President, Matisse, say, na ekoso. Enti Mr. Mame copy of the petition. Na mi read between the two offices, no, enka onyan to mara. Now, to leak that petition to people, to the extent say, Tafo MP, benya copy. Na audio court, na abeye social media debate, it means there are some malice occasion in this particular instance. So if there's an issue, how the situation, the real deal, how it's supposed to happen. First, constitution no can clear say obia krabaka as the principles of natural justice dictate. The accused person must always be heard. You can never go through a trial. Nipa na ye di nasem anase ade bi kotia no anase de ekoso no ne adverse consequences betimi akonipa no so no. The principles of natural justice dictate say that person must be given a fair hearing. And even it is in the constitution under the provision, it is there that the Chief Justice must be heard. But the question is, the first step in this particular instance, that process is not an adversarial process. Any adverse finding beyond betimi call against the Chief Justice. And at that point, the President cry nyam mawo akwanya say petition, Jacopia. You don't rush to ask for the petition because the constitution are making it quite clear, say either the Chief Justice in person or through a legal counsel and non-legal representation, she must be heard. It is quite clear. So at the early stage, you forward the petition to the, because it could be said petition will not go beyond your friend saying Council of State. Na campese yet you side of the story. The petition may be deemed incompetent, it may deem frivolous, it may deem like unrelated to the constitutional way now because constitution not set out three cardinal things. Beyond that, any other reason be our Chief Justice Afrobia enya adwuma three misbehavior, incompetence, and infirmity, both body and mind. So anything outside this realm of description or as stated in the constitution beyond all the choir is frivolous. They can throw it away. So that determination has to be done. At that stage, I'm saying that process is not an adversarial process. Any adverse finding be able to also a Chief Justice. The next stage, you forward it to a committee. A committee number findings. And the findings can be positive, it can be adverse. At that point, the principles of natural justice dictate to say the accused must be given a hearing. And at that point, it is under Article 146. That was quite clear, say the Chief Justice must be heard. And at that point, President no sound will right either because the Constitution has stated quite clear. Say you move from the stage Council of State now say, the premier facie has been established. We need to proceed to the next stage. Now President sa committee na on better na sem no so ahwehwe mu na at that point me say the Chief Justice will be heard. Sa process no course na say yentie no ana ya man petition no bia at that point anybody at all can go to court and challenge the president because at that time the president will be acting illegally. Because that will be in direct contravention the provision under 146 because I can't clear say the Chief Justice must be given a hearing when that committee is set up. And even at that time, at that point, President, our choice. The Constitution says that the President may at that point suspend. May means that the President can decide at that point to suspend the Chief Justice until the process never end and answer your duma. That is a discretionary injunction on the President. that is a discretionary injunction on the president. Either say committee ne tenase na say omu tie chief justice na or develop investigations no koswa. The president no has that discretionary injunction either to suspend the chief justice on fie pending that investigation, and now say if the constitution say may not, that is a discretionary injunction. But where the president is forwarding the petition to chief justice, to council of state, that is not a discretionary injunction. That is a constitutional injunction on the president. It's mandatory. He has to forward that particular thing to them. Now from that stage, now you set up a committee. Now say at that point, yentie chief justice na no de na president afomemra. Now say yenye that stage. Now we cry the president has been benevolent enough. I'm told say abra na chief justice yeah back and forth ni nyina akra no. Na wa man copy dada. So say Tafo MP sorry say or court akosiki relief because president forwarded petition to council of state na onyama chief justice copy or the court because the process is illegal. They see say these are guys they just want media hype, they just want media attention because that particular suit are frivolous because already president nakra ID kan ama your friend saying way and then a woman is 10 days because we need a copy ya better amount 10 days. It means but say onyama na and I'm saying Drew because article 146 down was no cross state is started from your friends a baby a committee now set it up now wakase the chief justice must be given a hearing either or no ankasa and answer the lawyers. It's quite clear there. And there the better motivation there's Tafo MP at this time but time issues or the court in yes 10 hours a month for take or voice keke a month for who keke because you are clutching at straws. I think that there is too much dirty politics in this whole space. Because sometimes what in China give you that bad way about the prospect of our democracy as to whether say baby I hear cry between you do because we a young person who follow this whole thing and gender any trust and confidence because it looks there are a lot of attention seeking freaks on this highway. Attention seekers, people who are shopping for attention just to stay relevant in the media, and they take some sick decisions at some time what to say or a penny, and you respect them. These are people who occupy very revered positions. You don't expect them to act in the way they do, but sometimes it's very disappointing because at the petition we are or suit we to begin with. But maybe he just needed the media hype because TV3 Firefly will be a count something as for that will give him the needed publicity that he requires because there is no sense in this thing. Because Senka Chief Justice and so free sir legitimately no. I said at that point our president have forwarded the thing to your friend saying